Further, we are pleased to welcome Ms. Laura, and Mr. Paschal, two distinguished professionals from Blackpool Group, whose combined expertise spans decades in the field of contract management, dispute resolution, and international arbitration. Ms. Gray, a contract and commercial advisor, brings over a decade of experience across the construction and energy sector with a strong command in FIDIC, NEC, and bespoke contracts. Her work on major infrastructure and renewable energy projects across Europe, the Middle East, Africa, and along with her contributions to high profile arbitration cases, reflects a strategic acumen and global perspective. Complementing her expertise, Mr. Paschal, CEO and Managing Director of Blackpool Group, who internationally recognized for his leadership in conflict resolution and area. With over 30 years of experience, Mr. Paschal has led dispute resolution efforts on landmark projects such as HIA Airport in Qatar and Intel Infrastructure's facility in Ireland, and has provided expert testimony in judicial contexts, including Supreme Court of Western Australia. Together, their excellence in commercial and legal strategy, and we are honored to welcome them to share their insights on the evolving ADR landscape of Dubai and beyond, and to enrich today's proceedings with their invaluable experience. In the meantime, we would like to thank all the participants who are continuing to be engaged in today's virtual event. We'd like to inform you that the next speakers have shared their presentation in a form of video recording. We'll be playing the video in a short, and the speakers will also be joining us shortly. The video is playing now.
My name is Paschal. Judicial level, on a building moving for people. With me, Laura Geary.
Aspect of the modern land population which they will be sharing today.
Okay, we will start. It's really great to be here today, representing Dubai for this amazing Global South organization. And I'm very thankful to Mr. Inba and Esteemed for inviting Blackpool to speak at this esteemed webinar. My name is Paschal Baugh, CEO of Blackpool Group. I'm a Fellow of the Royal Institution of Chartered Surveyors and a member of the Chartered Institute of Arbitrators. I've been involved in countless arbitrations and also in the delivery of expert testimony in all judicial levels to and including the Supreme Court. And with me is Laura Geary.
Hi everyone, I'm Laura Geary and I'm an associate member of the Chartered Institute of Arbitrators. I have over 10 years of experience in contracts. I have a legal background with attending the BPB Law School in London, and I've also been involved in dispute resolution cases globally and in Dubai. We are delighted to be here to discuss an important and dynamic aspect of the modern legal landscape, arbitration. Today, we will be sharing insights into the involvement of public and private entities in the global arbitration, exploring key trends and developments within our jurisdiction, examining influential court rulings, and providing an overview of the institutional arbitration framework, and of course, discussing the current challenges and critical issues shaping arbitration today.
The involvement of public and private entities in global arbitration is the premise of the webinar today. A brief overview of arbitration. Arbitration is playing a critical role in global dispute resolution, especially in cross-border commercial activities.
The Middle East, and particularly the UAE, have positioned themselves as a key arbitral jurisdiction through reforms, institutional developments, and legal modernization, and this can now be seen in Saudi Arabia. So let's begin with the role of the public and private entities in the global arbitration.
An overview. Arbitration, as we know, serves as a preferred method of resolving disputes, particularly in international commerce and investment. The involvement of both public and private entities significantly shapes the arbitration landscape, bringing unique challenges and considerations.
So, public entities. Public entities include government and state-owned entities. Public authorities, many know them as. And these entities frequently engage in arbitration, especially in sectors like infrastructure, oil and gas, energy, and large-scale construction projects. But one of the primary drivers for public entity involvement in arbitration is the need for, firstly, neutrality and enforceability, especially when dealing with foreign private entities. For example, in the UAE, where I currently work, ministries and public entities commonly include arbitration in concession contracts. DIAC and ADCCAC, Abu Dhabi, have handled disputes involving semi-government bodies. An example of a state-owned dispute is in the case of Honeywell versus Maydan Group, LLC, UAE, where Honeywell instigated an arbitration against the Maydan Group, LLC, citing that there were contractual breaches related to the construction of the Maydan racecourse.
Another significant case is the Nakheel Properties Arbitration, UAE, where Nakheel, a subsidiary of Dubai World, faced claims from contractor and investor over stalled real estate projects following the 2008 financial crisis. These cases highlight how public entities can be the respondents in arbitration, as well as being the usual claimants, emphasising the importance of having robust dispute resolution mechanisms in place.
It should be noted that due to the mass development in Saudi Arabia, which we're all seeing, and this particularly Vision 2023, has been encouraged for neutrality of arbitration on many contracts, including state-related contracts. This has seen projects such as NEOM and the Red Sea project using arbitration clauses to govern their contracts under SCCA rules, Saudi Arabia. The Royal Decree number M/34, 2012, you might want to note this down, allows the state entities to resort to arbitration with specific approvals. This sees Saudi Arabia following the successful formats in the UAE, which we all see today. Private entities. So, private entities, on the other hand, include multinational corporations, private businesses, and individual investors, construction and oil and gas, real estate, energy, finance, to emphasize some of the top sectors using arbitration today. These entities often turn to arbitration for resolving commercial disputes, contractual disagreements, or cross-border trade issues. Therefore, seeing arbitration clauses as the commonplace, particularly in JVC agreements, credit contracts, of course, and shareholder disputes.
An example of a private arbitration is the Raiffeisen Zentralbank Österreich AG versus 5-Star General Trading LLC. However, one party challenged the award in court. The case reached the Court of Appeal, where the party appealed the arbitrator's decision on a point of law. This case involves the financing and insurance of a vessel. Also, in another case, the Narciso versus Nash case, that's UAE DIFC Court of the first instance, addressed the enforceability of the DIFC/LCIA arbitration agreements, underscoring the jurisdictional complexities involved in cross-border disputes.
But it should be noted, which has been a course of discussion for the past 2 years at Dubai Arbitration Week, is the growing presence of regional family-owned conglomerates and SMEs using arbitration. Well, there's many reasons for this, but with the handover family businesses to the next generation, this can cause different ideals on driving the business forward, and this can lead to disagreements over the business and the future of it, which sometimes needs to be effectively resolved with the intervention of an arbitrator.
It is essential to understand the distinctions in procedural approaches when handling disputes involving public versus private entities. For instance, in cases involving public entities, issues such as state immunity and enforcement against public assets often arise. As seen in cases like the Dubai Court of Cassation Judgment number 735, 2024 in the UAE. In contrast, private disputes typically focus on contractual interpretation and financial settlements, as demonstrated in the Raiffeisen Zentralbank Österreich AG versus 5-Star General Trading, and that ended up in the UK Court of Appeal.
There has been great growth in the Middle East with regards to arbitration in the last 10 years or so, and therefore making a significant competitor with the traditional arbitrational houses of London, Paris, New York, Stockholm, and let's not forget Singapore. This can be seen with DIAC being restructured under Decree number T4 of 2021. It's consolidated the DIFC and LCIA in the UAE. Saudi is rapidly growing credibility with its rapid growth and its 2023 SCCA arbitrational rules. One of the most significant trends is the increasing use of hybrid arbitration models, combining institutional rules with ad hoc flexibility. This trend reflects the need for structured processes while allowing parties to tailor specific aspects of the arbitration to their needs.
Another key development is the focus on efficiency. Many arbitration institutions have introduced expedited procedures aimed at reducing the time and cost of dispute resolution. This is particularly beneficial in commercial cases where prolonged arbitration can impact business operations.
Digital and remote hearings have become more common, particularly after COVID-19 pandemic. And these innovations improve accessibility, but also introduce challenges related to data security and procedural fairness. But let's remember that SCCA Saudi Arabia has launched the SCCA case management platform, engaging end-to-end digital arbitration.
Transparency is another critical area, especially in arbitrations involving public entities. As public funds or state-owned assets are involved, there is a growing demand for more open and transparent arbitration processes.
Lastly, sustainability and ESG factors are increasingly considered in arbitration, and especially in Dubai, we're seeing sustainability coming to the forefront and an important part of the construction industry. As global awareness and around environmental and social government grows, arbitrators are being called to address disputes involving sustainability standards and corporate responsibility. As previously stated, there has been significant growth in the Middle East market with regards to arbitration. And this can be seen with the emergence of arbitration weeks in both Egypt and Lebanon. And Lebanon currently happening this week. With the focus on the UAE and Saudi Arabia, there has been some influential rulings by the local courts impacting arbitrations and ensuring the confidence that is given to arbitration in this region.
In the UAE, Dubai Court of Cassation judgment held that the Dubai courts had jurisdiction to hear a dispute despite one of the underlying contracts containing a valid arbitration agreement. DIFC courts, recognised as seat neutral and arbitration friendly, allowed enforcement of non-DIFC seated awards. In Saudi Arabia, Enforcement Court in Riyadh 2020 recognised a US seated award under the New York Convention, confirming growing confidence in foreign arbitration.
It should be noted that Saudi courts have recently first dismissed objections based on Sharia non-compliance, provided commercial context is clear. Second, honoured arbitration clauses even when the government-related entities were involved, subject to cabinet approval.
Dubai's arbitration framework is governed by the UAE Federal Arbitration Law No. 6 of 2018, which aligns with UNCITRAL model law. The key institutions are, in Dubai, we have DIAC and DIFC. In Abu Dhabi, we have ADCCAC, where Saudi Arabia's institutions and law are based on the following: SCCA Rules 2023, based on UNCITRAL, but with local enhancements, all of which allows parties to choose foreign laws and seats.
These institutions offer well-defined procedural rules, including the ICC and LCIA standards, ensuring consistency in arbitration proceedings.
Furthermore, the New York Convention ensures that arbitral awards issued in Dubai are enforceable in over 160 countries, highlighting the global reach of the arbitration framework. And note to all, if you're going into arbitration with a foreign company, you need to be sure that the jurisdiction is signed up with the New York Convention, or the arbitration may be unenforceable. Arbitration continues to evolve as a fundamental method for resolving complex disputes, particularly where public and private interests intersect. The dynamic nature of SCCA and DIAC showcases the jurisdiction's commitment to maintaining a modern and robust legal framework. By adapting to new challenges and embracing hybrid models, digital innovations, and sustainable practices, arbitration remains relevant and effective. Practitioners must stay vigilant, informed, and proactive to navigate this evolving landscape. UAE and Saudi Arabia's proactive approach to maintaining a fair and efficient arbitration system underlines its status as a global hub for dispute resolution. Thank you for your time today, and we sincerely appreciate your questions and comments. We'll retrieve all contributions from the webinar chat. If you didn't have a chance to post your question, please feel free to email us at info@blackpolegroup.com and we'll get back to you promptly. If you'd like a copy of the slides or the full presentation, we'd be happy to share them upon request.
Thank you very much, Pascal, and it's been a pleasure to be part of this session. And I really appreciate your engagement throughout and everyone present here today.
I see we have some questions here. Will we go to the questions, or shall I answer them in the chat?
You should address them now.
So the role of the emergency arbitrator. Emergency arbitrator normally happens before a tribunal is formed, especially where speed, privacy, and neutrality is critical. So it's just a faster way of getting it done. Cases of freezing assets or preserving evidence. So it's a useful strategy when speed is of the essence.
I'll just jump in. So Mr. Habib asked about technology, COVID, everything. So virtual hearings, digital platforms, we're seeing fast improvements, and direction in that, well, it's heading in that direction. But one thing I will say, as I said in the presentation, the SCCA, Saudi Arabia, is now created a digital platform, and that's really moving the space forward. So reducing costs, efficiency, and therefore we're seeing more cross-border arbitrations. So yeah, just to answer this question.
Very good. We have another question here from a student looking to specialize in arbitration, international arbitration, especially in the MENA energy sector. So competencies that you should be trying to build, you're going to understand the frameworks of the DIAC, the SCCA and the ICC. You're going to have knowledge of energy law, familiarity with the civil law systems, and you want to have cultural awareness, preferably be able to speak Arabic if you're going to be operating on legal matters here in the region. Now, the next one.
There was one just above.
Yes.
Yes, a lady or gentleman, excuse me, asked about arbitration clauses, enforcement in license agreements. I would advise you to look at the federal clause number 6. That details that in full. But yes, the answer is yes, they are.
Very good. We have another question here. Why is arbitration becoming more popular in the Middle East? So it is becoming more popular because governments are reforming their legal systems, trying to attract foreign investment and improve their dispute resolution mechanisms. So in the UAE and Saudi Arabia, for example, there are new laws and institutions like the DIAC and the SCCA and support of court rulings, making the arbitration faster and more reliable and internationally recognized. There's another one here. Can both public and private entities use the same arbitration rules and institutions in the UAE and Saudi? So yes, of course they can. Both public and private in Dubai can go to arbitration on the rules DIAC and ADCCSE, and in Saudi the SCCA can be used by both public and private, but in public usage, there are some requirements. There might be cabinet permissions or some modifications may be required just to accommodate the specific case at hand, depending on various factors.
And there was another one. Yeah. So the 2021 decision. Okay. So basically, it just reinforces the principle of arbitrator independence. Absolutely significant. And it just shows that, Dubai courts won't easily overthrow a decision on minor technicalities. And it just boosts confidence in arbitration. So yeah. And making it competitive with New York, London, Sweden, as I've really said already. So it's great for the region.
I think that concludes all the questions. Thank you very much for attending this webinar. And if you have any questions, please feel free to contact us either through the forum or just contact us at info@blackpolegroup.com. Thank you very much, everybody.
Thanks.
Yes, thank you. Thank you, Paschal and Laura, for narrating. I have to apologize for the technical glitch, what happened, but ultimately it came out with an excellent output. And thanks for answering all the aspects, particularly the questions on the court of cessation, the institutional arbitrations, and to what extent the private entities and the public entities getting involved in arbitration in UAE. This market, what practitioners, particularly from Global South, are significantly started using. And institution entity like yours would be a real asset and getting into the promotions of arbitration, particularly for the clients who wanted a solution which is obviously recognized across the jurisdiction. That's very important. And being part of this ecosystem, which is UAE and Saudi Arabia, the presentation was very significant when there was mentioning about SCCA, Saudi Center for Commercial Arbitration, I have to thank both of you to share this very significant institution in the Kingdom of Saudi Arabia, which is one of such institutions which started the meta to be used for resolving the dispute so effectively. Thank you. Thank you for the wonderful presentation. And in a traditional way of thanking from our jurisdiction, Nandri, Mikka Nandri.
Thank you very much.
Thank you.